setting up, with my respectful submission, can be related to the historical facts which has already been argued by Dr. Dhawan, how it was set it up in TMFI. So once you set up an institution, you exercise your choice. That could be a primary school, and that could be a university. Now, after 1950, my lord, it becomes a fundamental right. Once it becomes fundamental right, then the entire system is obliged to give effect to that right to choice. Maybe that I may have to, I may be interested in establishing medical college. Medical college is not a university. I'll go get myself registered under Societies Registration Act. Myself registering into Societies Registration Act will not be termed as establishing an institution. It will be only a compliance of an statute which is existing to promote excellence, which has been argued. So this word setting up to establishment, the word used in 1950, I think, my lord, that needs little bit explanation on this. My lord, chart 4, page 4, volume 1E, my lord. I'll just quickly run through. It's only one page, my lord.
The table?
A table, my lord.
Where is that?
1E, page 4. This is all taken from Aziz Basha. On the left-hand side, my lord, Aziz Basha says, educational institutions are of very wide import and would include university also.
He is not opening.
Yes, sir. My lord, 1E.
1 is both for Brother Suryakant and me is not opening. We've got it displayed now.
Share it. I'll share it.
Yeah, thank you.
Good.
It's also on the
Yes,
screen.
now we've got it on the screen. You can just tell us, yeah, education.
Page 4, my lord. This is both sides is Aziz Basha, my lord. I have given pagination. I'll not go there just to save time, my lord. Educational institutions are of very wide import and would include a university also. That's what Aziz Basha says. Now, right-hand side, my lord. Before Constitution came into force, most universities were established by legislation. So it's all right. Not disputed. I am on the left-hand side. Not disputed by the Union of India, and hence it may be accepted that a religious minority had right to establish a university under Article 31. So in Basha also, the stand is that yes, you can do that. Then third, my lord, it is true that the nucleus of Aligarh Muslim University was the MAO college. And on the other side, my lord, if your lordship sees, conversion of that college into university was not, however, by Muslim minority. So what was this conversion? Conversion was legislation. It took place by virtue of central legislation. Now I will come left side, my lord, once again. It may be that 1920 Act was passed as a result of efforts by Muslim minority. Right-hand side, but that does not mean that the Aligarh Muslim University, when it came into being under 1920 Act, was established by by Muslim minority. Fifth, my lord, there was nothing in law then to prevent them, MAO or university foundation, from establishing university if they so desired without asking government to help them in the matter. But if they had brought into existence a university on their own, the degrees of that universities were not bound to be recognized by the government. That is the genesis, my lord. The entire thing falls back to recognition. In 1920, in 1950, Article 30, terminology is used, established. So that recognition becomes established. That's the interplay. How this was argued, my lord, this is also interesting. In Aziz Basha, when the matter came before your lordship, it was only in relation to administer. It is the Union of India that took a stand that, sorry, this university is not established. So the entire debate went in the line of established. Your lordship may have this for a moment, my lord, 3A. I just want to show that, my lord. 3A, my lord, page 7, my lord. 3A, page 7. This was not an issue of whether established or not established when Aziz Basha came here. 3A, my lord, page 7, my lord. May I read the last para? The petitions have been opposed on behalf of Union of India, and the main contention is that Aligarh Muslim University was established in 1920. So this is what they said. And establishment was not by Muslim minority, but the government of India by virtue of a statute, namely 1920 Act, and therefore the Muslim minority could not claim fundamental right to administer Aligarh Muslim University under Article 30. So this came during the argument from Union of India. Now this will become more clear, my lord, if your lordship comes to page 16, my lord. Placitum E16. In the middle, my lord, this is a small para of 5 lines. Page 16. The contention of the petitioner is that by these drastic amendment of 1965, Muslim minority was deprived of the right to administer Aligarh Muslim University, and this deprivation was violation of Article 30. So the issue was this, Placitum E. But Union of India says that, so that's why it becomes, entire debate becomes established. So I'm coming back to, my lord, that volume 1E, my lord, table 6, my lord, page 4 of that volume 1E, that table Roman 6 on the left hand side. There was nothing in 1920 to prevent Muslim minority, if it so chose to establish a university. It did so. If it did so, the degree of such a university was not bound to be recognized by the government. It could not insist that the degree granted by the university should be recognized by the government. Now on the right hand side, my lord, by Act of 1920, degrees were recognized by the government. Hence, an institution was brought into existence which could not be brought into existence by private individual. Then, my lord, 1920 Act is circumstance to show that the university came to be established in 1920 and not by Muslim community. Such recognition dependent upon the will of the government, generally expressed through a statute. This narration is for pre-independence time. Now, Article 30 is altogether in different shape, manner. It is part of part 3.
That's nice. That becomes so low.
This is only reproduction of the sections, my lord. There is nothing more. Just for ready reference at one place, your lordships can get. But and I'll not read. I have read it yesterday.
Which page are you on?
2I.
How long is this note?
So 4 pages.
I read it now. Will be a good recap of your submissions.
Yes,
on this.
kindly, my lord, allow me, my lord. Lord, I have said that it was not established by the minority. Now I am on the question of administration, whether minority had any predominant role in the administration of the university as it stood in 1920, because that is the test your lordships would consider applying, not the test of today. Even today it's not, my lord, administration by predominant minority. But my lord, I am on right now on the Act of 2020. I'm sorry, 1920.
Yes.
A, as the Act stood in 1920, it was not administered by minority. Section 13 provides for Lord Rector. Your lordships have read, my lord, he had the supervening powers. Then 14, visiting board. My lord, your lordships have read it. I'll just read, my lord. No Muslim, my lord. The visiting board of the university, if and when the United Provinces of Agra and Oudh becomes a governor's province within the meaning of Government of India Act, shall consist of governor thereof, the members of the Executive Council, the ministers, one member nominated by the governor, and one member nominated by the minister in charge of education, provided that until a governor's province is so constituted, the lieutenant governor of the said provinces shall discharge and perform the function duties of visiting board. The visiting board may, by order in writing, annul any proceedings not in conformity with the Act, statutes, and ordinances, provided that before making any such order, the board shall call upon the university to show cause why such order should not be made. So, university was subordinate and subservient to a body which was consisting of non-Muslims. Then your lordships may, my lord, see, officers of the university are provided under section 16, which also do not mandate to be belonging to Muslim religion. The chancellor, the vice chancellor, the pro-vice chancellor, your lordship would recall the court provision for court says that all members shall be Muslim. These people need not be Muslims. Then, my lord, there are three authorities. The court, executive council, and academic council. Though section 23(1) proviso provides that no person other than a Muslim shall be a member thereof, the court was never conceived to be a body having power of administration, but was given only residuary power under section 23(2). My lord, the petitioners read first part saying that it would be the main body, without reading the second part, namely subsection 2. Provided that no person other than Muslim shall be a member thereof. 2. The court shall be the supreme governing body of the university and shall exercise all the otherwise provided for by this act, the statutes, the ordinances, and the regulations. It shall have power to review the acts of the executive and the academic councils, save where such councils have acted in accordance with powers conferred on them under this act, the statutes, or the ordinances, and direct that necessary action may be taken by the executive or the academic council, as the case may be, on any recommendation of Lord Rector. Again, Lord Rector supremacy, my lord, is conceived. Then, my lord, 13, Lord Rector, the Governor General, my lord, now it is the Governor. Governor General shall be the Lord Rector of the university. The Lord Rector shall have the right to cause an inspection to be made by such person or persons as he may direct of the university, its buildings, laboratories and equipment, and of any institution maintained by the university, and also of the examinations, teaching, and other work conducted by or done by university, and to cause an inquiry to be made in like manner in respect of any matter connected with the university. The Lord Rector shall in every case give notice to the university of his intention to cause an inspection, so and so, so and so. Please see 5, subsection 5. Where the court does not, my lord, he has a power to direct the court that you do this. Where the court does not, within reasonable time, take action to the satisfaction of the Lord Rector, the Lord Rector may, after considering any explanation furnished or representation made by the court, issue such directions as he may think fit, and the court shall comply with such directions. My lord, the simile which was sought to be given, that your lordships are visitor to some university, my lord, is not the simile in the context, is not the correct simile in the context of the question your lordships are deciding. The question is, who is the ultimate decision-making authority in terms of administration?
There are two ways to look at administration.
My lords.
One is with whom the absolute or the final power is vested.
Correct, my lords.
The other is day-to-day administration, day-to-day running, functioning of the institution. The day-to-day functioning is done by the people who are at helm of affairs, who are hands-on. Lord Rector, being the direct Governor General or somebody, will be having numerous functions.
Correct, my lord. On site, who is, my lord, either of them, my lord, there is no
So-
dominant
so-
control.
so as per your argument, it's going to be the ultimate authorities and not the ones who are, because this argument proceeds on the basis the one who are actually running the day-to-day administration. Like in criminal law, the persons in charge of and responsible for administration are the ones who can be prosecuted. Day-to-day affairs of
Your
administration.
lordships are right.
And not the one who's overall in charge, or not the one who's a symbolic in charge.
Yes, my lord, even
No,
day-to-day
our
administration.
argument, which is to be answered.
Please.
This has to be.
No, right, Mr.
What?
Lord, my
Point of view, yes.
decent
I
fee
hope
be
we'll
not
get the
treated
time.
as my weakness.
That's fine.
Mr. One.
He's not responding to our argument.
Mr.
I hope we'll get the time.
Dr. Dhawan, we'll hear you and rejoin. There's no difficulty. We'll hear you. Yes.
Lord, here, even day-to-day administration is not in their hands. Lord, the court was consist of some 100 and some odd, my lord, people. Lord, they can't be running the
actually,
administration.
Mr. Solicitor, the argument which was made on the other side was this, that you can establish institutions of your choice and you have a constitutional discretion to administer it. But if you give that discretion, exercise that discretion by giving the administration to others who do not belong to a minority, that does not detract from your position under Article 30. For instance, in any educational institution,
Correct.
there will be non-minorities who will be an accountant, who will be performing other ancillary functions. That by itself may not be an indicator that you cease to be a minority.
Even that discretion is not there. That's
Of course.
what attempt, my lord.
Yeah, of course, you have said that, here the statute superimposes the Lord Rector. And
Yes,
we'll hear the
No,
other
I'm
side. of
saying
it.
something else,
Yes, in fact,
my lord,
yes.
something else as well. Even in terms of amending the statutes, they have no supremacy. They can amend the statute, it is always subject to
The government.
rector, the Governor General in Council, full right to set aside it, remit it back, or say that I don't accept it, reject it. So meaning thereby they had a kind of advisory function. That this is what we think the statute should be, and according to us, this is how the administration may run. For example, the statute concerns the administration. That also, my lord, the discretion also is not conferred. Please, my lord, see further.
Obviously, it was the policy of the British government to not make this an absolutely autonomous institute. They were retaining some element of control over the institute.
Substantial and predominant, that's my submission, control. And, my lord, this statute be not examined, my lord, my respectful submission, in the context of or under Article 30. It was not there. If any parliament were to make this statute possibly an argument, not possibly, argument can be made that this is violating of Article 30. But there is a history behind it, that we will have control and there would be no denominational character. Are you agreeable? They said, yes, we are agreeable.
Anyway, there is no challenge to the provisions of the Act.
There is none. Well, even the
Therefore, we proceed on the basis that
provisions
the
of
Act
the
is valid.
amendment is not under challenge. Post-constitution amendment is not challenged under, my lord, except 81 amendment.
So we take the Act as it stands and see what is the impact on its minority status.
Yeah, kindly, my lord, therefore, my lord, kindly see, my lord, para 8. The power to establish and maintain colleges and schools was subject to
If a similar provision were to be made today, Would that detract from the minority status of the institution?
It may, my lord, it may. My lord, the government may not, my lord, the present government under the constitution cannot compel them that either of these things to you agree, otherwise will not pass an act. I am not for a second saying that that's the prerogative. The legislature may in its wisdom say that we will accept this or we will not accept this, but subject to judicial review. But in 20, the crown, the
test would be this. The true test would be this. Which of these provisions are relatable to the overall regulatory power of the state, which even Article 30 allows, and which of these provisions go beyond what is really a regulatory provision, which is agnostic to religion,
correct, my lords,
and then destroys the minority character.
correct, my lords, but please, my lord, again, my lord, at the cost of repetition, please do not read 1920 Act in the context of Article 30. It is at a period of time in history where Article 30 was not there. Indian Constitution was not there. There was no concept of minority. There was no concept of fundamental rights. And the British government was in a position to put its terms. If you want this, have it. Otherwise, others did not agree. They started their own universities and started conferring degrees. Because till 56, it was not impermissible to have universities and degrees. This degree was needed by the Aligarh Muslim University.
Really speaking, what your contention boils down to is this, that this was not a denominational institution when the university is established in 1920. Therefore, the subsequent development, namely the adoption of the Constitution on 26th of January 1950, cannot confer upon it a denominational character for the reason that you had bartered, you had surrendered that denomination.
And that is the ratio in Basha.
That is your submission, which we got the point. We'll have to hear the rejoinder.
Lord, kindly, just quickly, my lord.
Yes.
Section 12.
See, let's see section 12.
Section 12, my lord. 3, my lord. The most important power for any university is to affiliate other colleges, etc., my lord. That's the most important administrative power. Please see. The university shall, subject to statutes, have power to establish and maintain intermediate colleges and schools within such limits in the Aligarh district as may be laid down in the ordinances for the purpose of preparing students for admission to the university, and may provide for instruction in the Muslim religion and theology in any colleges and schools with the approval of the academic council and the sanction of Governor General in Council on the recommendation of the visiting board, and subject to such conditions as may be prescribed by the statutes and ordinances, the university may admit. So, my lord, first supervening power of Governor General in Council, this is the major administrative act. Thereafter, the visiting board, and subject to the statute, and your lordships would recall, the first statutes were framed by the imperial parliament itself, providing that you cannot amend that statute without my permission. Even the ordinances were framed by the Governor General in Council. So please come to page 4.
Didn't want to give a complete free hand, they realize the importance of education and the impact they'll have, because
they wanted a degree, and for that degree had a price in those days, price not in terms of money, that you have to accept what government said.
It was perhaps more than that. They wanted to have control, overall supervisory control, so that they could intervene and interfere.
In the administration, there was no absolute discretionary administrative power conferred under 1920 Act. And the history, my lord, is the proof of that we will have two things, no denominational character, and we will have administrative control. And they were in a bargaining position. There was no constitution. Having a minority institution or having a university was never a fundamental right. And majority of them did not do it. They accepted, my lord. And I wanted to cite, but I am not citing, my lord. I request somebody else to cite. My lord, one of the latest written by the then management to the governor, my lord, is shocking. That we want that your British administration continues in this country forever. It's a boon for our nation, etc. But I don't want to digress from that. But my colleagues are citing it. Please come to page 4. So that was the mindset or the object which they are entitled to have. They were entitled to have. With which they surrendered everything. And let check whether we discuss that.
Basically, this is a pre-constitution institution.
My lord.
We will have institutions which are claiming the right under Article 30. Any institution which fulfills the requirements of Article 30 is entitled to claim a right post-constitution, irrespective of whether it has been established prior to the constitution or after that. The law is not that you can claim the right under Article 30 only if you have been established after 1950. Now we are dealing here with a pre-constitution institution. Second, an institution which is governed by a statute.
Correct.
Now, there are certain, and we are looking at the antecedent facts prior to the onset of the Constitution, prior to the adoption of the Constitution. We have to also understand that that was a period when there was absolute control which vested in the imperial power, right? Now, to what extent was this absolute power, which was yielded by the then imperial government, so destructive of any claim in regard to minority status post-constitution? So, contrary to what you are saying, we are not applying Article 50 to a situation pre-constitution. To a certain extent, you have to do that exercise. Otherwise, we will be coming to the conclusion that no pre-constitution institution can claim a constitutional right under Article 30. That's not the position. We can't say that a pre-constitution institution is not entitled to claim the right under Article 30 of the Constitution. Obviously, they are. So long as they satisfy two yardsticks, namely of being established by a minority and two, being administered by a minority. And now here, there is an issue because you're placing in issue the fact that this was really an institution which is established by the statute, according to you. That's what
So
the
they
preamble
had
said.
other options of establishment.
That they need not have gone the statutory way. According to you, they could have followed the Vishwa Bharati route. You could have,
Yes, yes.
or any other
I'll
institution
not
where-
surrender my rights and
where
reclaim
you
their
don't
right
seek,
after
you
independence.
don't seek recognition of your degrees, in which case you could have just said, well, I'm going to be an institution which will be standing alone on my degrees, even if they're not recognized.
Stephen did it.
My students will not get government service, but so be it. Many other institutions did it. Stephens did it. Vishwa Bharati did it. That's one aspect of the matter. But does the fact that they really chose the statutory way, is that so destructive of their claim to minority status? Post-constitution.
Your lordships, with a
In
profound
which case we will be saying that once you accept the fact that you will be governed by a regulatory statute for the purpose of the
It's not
conferment
a
of
regulatory
degree,
statute.
it is a regulatory statute.
No, it's a substantive statute providing for substantive either power or lack of power.
But regulatory statutes are also substantive. They're not procedural.
There are three things, my lord, in this statute of 1920.
Does that completely destroy its claim of minority status?
Correct.
Or are these provisions which are designed to ensure the proper administration? Now, Governor General, let's take the case of the Governor General. You will find in a large number of institutions today, there is an approval required of a government officer, minister in charge of education. Are these really, in that sense, are they controlling influences? Or they are there in the manner of an overall supervising influence to ensure that nothing drastic is done? We must also understand that the British government they had sensitivities. They didn't want any one institution in India to become so powerful so as to affect the imperial dominion power.
No, they say otherwise.
They were not running these institutions.
I'll answer that.
This was all designed to ensure ultimately that no institution went out of the mainstream as they wanted it.
No, my lord, and some movements which were started doesn't spread across the nation. That was the reason, the movement of independence, and that was the reason why most of them said, no, we would prefer movement and not your.
Therefore, all the regulatory statutes were intended to provide one overarching objective. And that objective was nothing should be done to destroy the hegemony of the imperial government and the colonial power. Protect the colonial power.
Maybe as a general
And
purpose.
education is a very important source of, it's a source of cultural power. And we have seen it pre-independence and we have seen it post-independence.
May I answer your lordship's question? Lord, first of all, the establishment is a fact which is pre-independence, which cannot be wished away even after the independence. How it was established, number one. Number two, in my most respectful but very emphatic submission, these are not regulatory provisions. These are substantive provisions, either conferring powers or not conferring powers. Number three, when we talk of administration, we never talk of administration in air. Administration is always a layered exercise. For example, my lords, administration of a court, let's say for a particular high court, there would be 5 registrar generals, registrars having different powers. They would be administering, but according to what? According to something which is decided by some higher authority. That higher authority would not be doing on day-to-day basis the administration. Thereafter, the administration would percolate. But ultimately, the controlling thing would be the statutes. Controlling thing would be, in case of a high court, the resolutions, the constitution, etc., passed by the competent authority who has the ultimate control. So, my lord, please, my lord, do not take these as mere regulatory provisions. These are substantive provisions. Either we confer these rights A, B, C, D. You are not supposed to do X, Y, Z. It's very clear. These are power conferring substantive provisions under the 1920 Act, not just regulating who will administer. They are not, my lord. Therefore, my lord, please see, my lord, page 4. Please see page 4, my lord. And establishment is a factum. Whether I succeed or we succeed or other side succeeds. Establishment is a factum which has taken place in 1920. That cannot be wished away. What the British did may have been completely wrong, but it has happened, and majority of the institutions have chosen to ensure that that does not happen with them. They came after the constitution and said that now make us a university or deemed to be the university because we established ourselves. We established this institution. And we have maintained its independence. We are administering it without any outside interference. In this context, please see page 4, section 28. J, ground J. Both the ordinances and the statutes, these are the administrative governance documents. A will have some powers, B will have some powers, C will have some powers, and Pune will have some duties. Powers coupled with duty for everyone. That would be decided by ordinances and by the statutes. Correct? That's the administrative structure substantially provided as a substantive provision in the Act. Statute could not have been amended without approval of the Governor General in Council. The power in this regard was so wide that the Governor General in Council could reject the amendments proposed by the authority of the authorities of the university. The relevant provision are section 28(2)(c) and 33. Please read this. No new statute means after the first statute which were made by the Imperial Council. No new statute or amendment or repeal of an existing statute shall have any validity until it has been submitted through the visiting board, completely non-Muslim visiting board, which may record its opinion thereon to the Governor General in Council, and mark this word, my lord, and has been approved by the latter, who may sanction, disallow, or remit it for further consideration. It never was.
Yes, Mr.
Please. So the governance document, that registrar will do this, deputy registrar will do this, joint registrar will do this, court master will do this. I'm just giving a hypothetical example. And Pune will do this. That is the document, that governance document, which is the documents of administration. There is no power in the court, exclusive power with the court. the Governor General in Council would say that no, this is not acceptable. So similar is the position with ordinance. No new ordinance or amendment or repeal of an existing ordinance shall have any validity until it has been submitted to the court and the visiting board, which may record its opinion to the Governor General in Council and has obtained the approval of the latter, who may sanction, disallow or remit it for further consideration. My lord, the respectful submission is, as on 1920, it was neither established nor was being administered by the minority, and therefore their claim post-constitution would not sustain. Lord, I can say Mao, if would have remained Mao College, would have raised the claim after the constitution.
Suddenly said Mao, I said, where does Mao come from?
No. MAO, my lord, I'm sorry, not
Yes.
not Mao Zedong. No, I'm sorry, my lord. Mohammedan Anglo
Yes.
Oriental College.
No, lighter sense.
Your Lordships are right. That college could have raised, not could have, it could definitely have raised that we established it. We were administering it. We are a minority now post-constitution. Because before that constitution, there was no minority concepts. There were, all of us were subjects, Hindus, Muslims, Parsis, Sikhs, Jains, everyone. Now, we have been doing it. That's what, my lord, the Saint Stephen did. Saint Stephen did that, my lord. And
Right, now we have seen this note on
now
administration.
please
What
see,
is the next point?
post-constitution, my lord, I have given the chart.
Which is that chart? Post
Lord, page 5. Page 5. Post-constitution, after taking into consideration all amendments, my lord, as it stands today, as AMU stands today, is there any administrative control? Because, your lordships, it is not disputed that word "and" will have to be read as "and" only. Established and administered, not "or." It's not their argument also. Now, my lord, Chancellor need not be a Muslim under the new act. If de facto governor appoints him, doesn't make the legal difference. Lord, kindly see, my lord, if
How many chancellors have been non-Muslims actually in the case of the institute?
we have not examined, my lord, but possibly all were Muslims. That's the convention. I am on law. 23 or 25 so far. So, my lord, de facto status would not change the legal position. My lord, for example, Lord, suppose there had never been a lady attorney general. That doesn't mean that it has to be a man. It incidentally happened to be a man.
That argument may be slightly different. That argument.
But I'm giving the
that may
example
not
may be
be a-
different.
That would not be a correct argument.
Lord, example may be a different, my lord, example,
But when we are examining whether what has been the history in the past, whether administration can be only judged on the basis of what has happened and what has been actually after in last, how many, 1920 till we almost now going to be completing 100 years in another 3 years.
103 years, yes.
103
Lord,
years.
I
we
just
have
answer
completed-
that question.
Any time in the past where the chancellor, pro-vice chancellor, vice chancellor have been non-Muslims?
My lord, I'll check up and say, but not to my knowledge. Possibly they were Muslims.
And why
I
is
must be
it then
fair.
that governments, both before the advent of the
Lord, I'm told
constitution,
4 were non-Muslims, my lord. 4 were non-Muslims.
but why is it that before the advent of the constitution
Why
and post the constitution, the predominant choice of chancellors by successive governments has been of Muslims? That's certainly one factor which has to be borne in mind.
Lord, can by government appointing a particular community, though the law does not require it to do, change the character of that university, my lords?
It may
That
be
the
a
government
recognition.
keep on appointing Muslims,
Equally,
irrespective of Article 30, it's not established or
equally, as
administered.
you rightly said, that we have to look at it in a holistic perspective.
Yes,
Could it possibly be a recognition of the fact by successive governments that this is how they have been perceived at an administrative level
well, Lord, then
by
they
the
would,
university itself?
Lord, then they would not have required 81 amendment. If that was the interpretation, that is how it was being given, I'll come to, my lord, the periodical interpretation. Why I say, my lord, it need not be a Muslim, there is a reason. Your lordships have seen the provision of court, where there was a provision that all members shall have to be Muslim. That's the legal provision your lordship would bear in mind. Here it doesn't say the chancellor will have to be Muslim. Incidentally, it was a Muslim, he was a Muslim, he or she is different thing. That would not change your lordship's, my lord, adjudication whether this has a minority status or not.
There is one more thing. Suppose, let's assume it's a minority institution
Yes.
in a given case. The minority institution appoints a non-minority as the vice chancellor or chancellor. Will it make it non-minority?
It cannot. My lord, Saint Stephens, reverse, your lordships are right. Saint Stephens do not always appoint, my lord, principal from the Christian community.
Fairly speaking, therefore, when we look at the term administration, we'll have to take into account how actually it is administered on the ground.
The legal position, not de facto position. The legal position. My lord, in case of Saint Stephens, my lord, it is never that only Christians were appointed as principals. Then it's bad. That's not the concept of a minority institution. But Lord, my point is, your lordships will go by the statutory provisions.
Because our law recognizes the power of the minority to appoint the head of the institution. No outsider can be foisted. You may choose somebody else. You may have a distinguished nuclear scientist who's not a minority.
Ideally not.
Choice.
I'm
The element is not.
not saying
The
legally
element
wrong.
is the choice.
I'm not saying legally wrong. You should not confine the benefit going to the students to one community. There may be many other eminent people, may not be belonging to a particular community, who can take the institute to a further height. But you can't deprive the students of that. That's what as an ideal position, not legally, it is wrong.
Okay. Article 30 in the end uses the word choice. If by choice a minority institution agrees to abide by certain terms and conditions in order to establish itself and get certain, say, a degree, will they lose that by choice? If they do it, will they lose their minority status?
It is a minority.
It is a minority institution.
Undisputed minority.
Yes. By choice, they agree to certain rules and regulations and even administrative overall supervisory control. Will they lose their minority status?
Not after the constitution. If it is established after the constitution, no. My lord, for example, take a flip side.
Why should
Take a
that-
flip side, my lord.
Once you accept that, then why not before the constitution?
My lord,
Because once you accept, then the administration
Take
is
a-
with them.
my lord, take a flip side of it. My lord, suppose in Banaras Hindu University, as a tradition of a gesture of goodwill, the government continued, my lord, had continued. I'm giving an hypothetical example. Only Muslims are vice chancellors and Muslims in the position of power. Would it come, and I'm posing a question to myself, would it convert itself into a minority institution? If what example, my lord, we are discussing is true, the reverse also has to be true. If de facto can change the de jure position, then, my lord, it should apply to everyone. And, my lord, there are some benefits to a minority institution. From tomorrow onwards, my lord, some institution can start converting itself into a minority by merely appointing people. Though law doesn't require, the statute incorporating it may not require. Well, all British, my understanding is right, all British authorities were Christians in those days. So, my lord, de facto, what is the position is, in my respectful submission, irrelevant. It may be a practice, it may be a political stand of the government, it may be, my lord, for various reasons, as the, my lord, in the initial Britishers also were requested that please, izzat ke liye, but that's the word which is used, take into account our feelings and have Muslims. Maybe that's the reason, but that doesn't define the character of the institution. But therefore, I say The way court mandates only consisting of Muslims with the provision
Let's
now.
quickly run through this chart so that we can go on to the next.
Here, my lord, when I say need not be Muslim means the law doesn't require him to be Muslim. He may be Muslim, he may be any other religion. Chancellor need not be Muslim, pro-chancellor need not be Muslim. My lord, throughout, I'm not reading it, up to proctor need not be Muslim. Then representatives of the department and colleges need not be Muslim. Some expert, my lord, in a chemical engineering branch may be sent as a member, my lord. He may not be Muslim. He may happen to be a Muslim. But the law doesn't say that a representative of department of colleges belonging to Muslim community. That's not the law. Need, therefore, my lord, I am carefully using the word need not be Muslim.
Okay, this, the chart in Annexure A is pre-1981 or post-1981?
As on date, as it stands.
And what was the position pre-81?
My lord, I have said, my lord, court is concerned, it was full Muslims. Till 51 amendment, it was deleted. 1951 amendment, which was deleted. I'll show, my lord, that comparative.
So this chart, this is as it exists
As
today.
it exists today. And as it exists today, my lord, if your lordships were to go, need not be Muslim. My lord, when I say, my lord, representative.
There may be slight problem in this because we have to deal with the, whether it's an institution which was minority or not, as on the date when the constitution.
Correct. This is irrelevant according to my submission.
So this 1981 amendment may not be so much, or post 1981
Yes.
may not be so much, because if it was a minor, you can, to that extent, there is no list of between the two sides. If it was a minority institution as on the date in 1950, then it will continue to be a minority institution.
My lord, the difficult.
Because they have challenged, some of them have challenged the 1981 amendment also.
Yes, that's the issue. That I'll come to that, my lord. And there, when the bill was introduced, it was introduced on the ground that Congress had that in the election manifesto.
There was
That was the ground. And there is a beautiful opposition by an eminent parliamentarian who was an eminent counsel of this court, Somnath Chatterjee, that you can't do this. This is not the way you take away basis of the judgment. I'll come to that. But my lord, there are only 35 persons who can be Muslims out of 189 as on date. Who can be Muslims, my lord, I am saying. Mandate, no mandate that they have to be Muslims. For example, my lord, representatives of alumni, past alumni. But there are all community students who are studying here. They have engineering college, management college, medical college, everything. Maybe other community people may represent that constituency of alumni. Two persons representing Urdu language, my lord, for example. He may not be a Muslim, my lord, but an expert in Urdu. There are people who are experts in Urdu. They can, my lord, be the representatives. So therefore, I carefully use the word need not be Muslim. The law doesn't require them to be Muslim. But 39, 35 people, 37 people may be Muslim. I am against, they also don't require Muslim. Please, my lord, come to page, my lord, page 8.
What is the reason to bring in representatives of Muslim culture and learning?
My lord, there is one of the subjects. The way, my lord, other subjects are taught.
Why do they at all have to bring in people who are representatives of Muslim
There is a
culture
small
and learning?
carve out.
Or what is the need to bring in, say, representatives of the All India Muslim Education Conference? What is the genesis of that?
My lord, just, my lord, if your lordship sees, there are several subjects being taught. Lord, there is, my lord, a separate constituency, representatives of teachers other than chairman and department and principals of colleges. So they have representation. Chemistry will have a representation, medicine, biology, etc., etc. But one of the, my lord, subjects out of several is Muslim theology and Muslim culture. Therefore, they have representation. But therefore, it does not say, the provision does not say they will be Muslims. Muslim Cultural Association will send 5 people. They may be Muslims. They may send others also. Therefore, I say what is required as per Kerala Education Bill is sprinkling of outsiders. This is not sprinkling of outsiders. This is predominant outsiders. If I may use that expression, nobody is an outsider, but predominant non-minority people. Yes, I'll now, my lord, come to, my lord, I'll just show the chart, my lord. My lord, the Chief Justice also, my lord, desired that there has to be on one page how the amendment took place. My lord, first in 51, 65, 72, 81. So we have prepared that chart. It won't take more than 5 minutes because we have depicted the amendment in different colors. So your lordship would get only in 5-7 minutes, my lord. The amendments.
Section 9 was amended in 51 or 59?
Pardon?
Section 9, that
51.
amendment, 51.
50. My lord, your lordships may see the legend on the top. Black is original act, my lord, as it stood. I'm sorry, my lord. What is in black is as it stood when the act was passed. Red is 51 amendment, orange is 65 amendment, gold is 1972 amendment, and green is 81 amendment.
All right.
Lord, the relevant would be, my lord, kindly see the green one, my lord, first. In 1981, an act to establish and incorporate a teaching, established and is deleted. My lord, with limited experience, my lord, I have come to know about such an amendment for the first time, where the preamble is amended, that it was not established. The historical fact is changed by making an amendment after about 60 years. And incorporation continues. So incorporation is also establishment. They possibly forgot, my lord, that established and incorporated. Now, please, my lord, see
No,
the rest of the.
there may be an alternate reading also, which is that the amendment to the preamble is to bring the preamble in conformity with a historical fact. And in that sense, it is
Historical
declarative.
fact, my lord, cannot be changed, my lord, by.
They're not changing a historical fact. They're changing the provision of an act which was inconsistent with the historical fact. So as to bring it in conformity with the historical fact. I mean, there's an alternate reading possible.
My lord, kindly appreciate.
One more thing. This is the amendment by the parliament.
Correct?
And is the government accepting the amendment or?
I'm not.
How can you not accept it, accept an amendment by Parliament? Mr. Solicitor, Parliament is an eternal, indestructible body under the Indian Union.
Correct, my lord, and
And
continuing.
irrespective of which government represents the cause of the Union of
No,
India.
I'm not saying.
Parliament's cause is eternal, indivisible, and indestructible. And we can't hear the government of India to say that an amendment which Parliament made is something I don't stand by. You have to stand by this amendment.
Allow me to answer that, my lord.
You have an option. You go
Allow
through
me
the
to
amending.
answer.
You have an option. Go through the amending route and change the amending act
Allow
again.
me to answer that
That's
question.
ultimate power.
My lord, allow me to answer that question. My lord, I am not arguing a matter of A versus B. I am before a 7-judge constitution bench answering constitutional questions. That is number one. Number two, the amendment in question was subjected to challenge before the High Court, and there is a judgment declaring that it is unconstitutional for ABCD grounds. And as a law officer, it is my right as well as my lord, entitlement and duty to say that this view appears to be correct. And third,
Mr. Solicitor, this will be radical, because a law officer will be then telling us that I don't abide by what Parliament has done.
my lord, in that case,
You have to stand by what Parliament has done, but Parliament is supreme. Parliament is undoubtedly supreme in its lawmaking function. Parliament can always amend a statute, in which case the law officer can say, well, I have an amended statute now, which I am going to place
your
before you.
lordships expect.
Can we hear any organ of the union government to say that notwithstanding a parliamentary amendment, I don't accept this amendment?
Lord, I am supporting the judgment. Lord, would your lordships, my lord,
In that sense, Parliament.
please allow me to answer this.
Parliament is, that's why I said, Parliament is an eternal, indivisible and an indestructible entity under the democracy.
No, I am not disputing that, but my lord, would you? I'm posing a question to myself.
How can you
Would
say
I?
that, look, I don't accept the validity of an amendment.
Hmm?
Or I don't
Lord,
accept,
no,
I
during
don't
emer-
accept that there was a ground for
Can
this
I
amendment.
answer? My lord? Yeah, it's more, my lord, one-sided there, my lord. Can I answer that? Would a law officer be expected to say that whatever amendments were made in the Constitution of India during emergency were true only because they were made by the Parliament? Here, I have a judgment of the
No,
Supreme.
but Mr.
Allow me to
Solicitor,
complete.
that's why the 44th
I
amendment
will not
came
raise
in.
that point, my lord.
That's why the 44th amendment.
Let others
came in.
argue, my lord. If that is so, my lord, I will not raise that.
If the 44th
my
amendment
lord,
came in only for that, the 44th amendment came to redress the evils which were perpetrated in the name of a constitutional
Who will
amendment.
decide, my lord, that these are evils being perpetrated?
Obviously, exactly, you prove my point. The power to decide that is in the elected body of the people, which is Parliament.
My lord, there is,
Parliament can always say that what we did during the emergency was wrong, and we are rectifying it by
Lord,
the 44th
not
amendment.
after it is set aside by the division bench of a high court, my lord, and therefore it is not on the statute book. And when I am not in A versus B situation, I am in a constitution bench answering a legal proposition, whether such a thing can be done or not. And if I do not do, and there is an affidavit filed by the government, it's not my stand, it could have been my stand also. But if I cannot argue, my lord, that this amendment could not have been made, I will have to support, I means any law officer will have to support every amendment made during emergency, irrespective of, my lord, whether it is my view or anybody else's view that this was to remove some anomalies or some bad things happening to the citizens of India. I'm sorry, please don't make it a political thing. Please don't do this. Then don't interrupt. Then don't do it. Then don't. You said don't. I don't want to interrupt, and then you interrupt.
Ability in court, please.
My lord, I'm sorry, my lord. Your lordships would come in. Your lordships would come in.
Let's not,
Argument.
Your lordships would come in, my lord.
Let's 1 second.
No, my lord. Here,
1 second, Mr. Let's not allow the pristine character of the dialogue to degenerate.
I'm
1
yes, my
second.
lord. This is
All right.
this
We'll
is
give you
unacceptable.
1 second. We give you 30 seconds to make a point of law, not on personally on the Solicitor General. Let's keep out personal, yes, just
I was
30
in
seconds.
court
yes.
on the day when the emergency argument was, I was only going to make a historical reference for us. I was sitting in court when the Attorney General of India, Nirande, was standing here and arguing that what has been done is right. I defend the emergency provision. Why? Because he could not say otherwise. It's only that I'm saying. But I was not going to say anything against him.
Yes.
I don't know why, but
No, my lord, you did say something. You used an uncivilized word which is not used in the court, and you generally do not use, maybe infected as of now. But, my lord, I'll say, your lordship, the distinction is, Nirende was not, my lord, in a situation where one high court had struck it down and the provision was not on the statute book.
yes, the
Here-
Madhya Pradesh High Court had struck it down.
9 high courts.
Yes. What do you?
There were other high courts which have upheld, and there is all your lordships are aware, Mr. Nirende told the court that if somebody is hanged, can we not do anything? Yes, he said, yes, we cannot do anything. It was not to defend it. It was to instigate the judges that please interfere. This is the position. Lord, everyone knows, my lord, there are two versions. When Mr. Nirende, the learned Attorney General, then told the court, when the court asked, do we not protect Article 21 if somebody is being hanged or his personal liberty is deprived? He said, yes, you cannot do it. It was not to defend the act. It was to instigate the court that this is the position. Please interfere.
Mr. Solicitor General, let's come back to the point. Your
Yes.
argument is that 1981 amendment, you need not to comment for the simple reason that by virtue of a judicial verdict, this provision has been erased from the statute book.
Correct.
That is what you want.
It is.
So we
It
can
doesn't
now-
exist as of now. I leave it at that, my lord. I will not be uncivilized in my lord arguments. Now, my lord, please come to Mr. Sibal is generally not, my lord. But uh, then, my lord, please see, my lord, 51 amendment first. My lord, 51 amendment is at page, my lord, section 8. My lord, please see section 8. It is made, my lord, this is post-constitution. The university shall, subject to the provision of this act and the ordinances, be
Section
open.
8, Section 8.
8. Read is 51 amendment, my lord. The university shall, subject to the provision of this act and the ordinances, be open to persons of either sex and whatever race, creed, caste or class, and it shall not be lawful for the university to adopt or impose on any person any test whatsoever of religious belief or profession in order to entitle him to be admitted therein as a teacher or student, or to hold any office therein, or to graduate thereat, or to enjoy or exercise any privilege thereof, except in respect of any particular benefaction accepted by the university, where such test is made a condition thereof by any testamentary or other so and so, so and so. Now, my lord, please see.
Provided that nothing in this section shall be deemed to prevent a religious instruction being given in a manner prescribed.
Yes, my lord.
By the
To prevent
ordinances.
religious instruction being given in the manner prescribed by the ordinances to those who have consented. My lord, this is 28.
Yes.
Article 20.
Just now, and now come to 28, Article 20. Just have.
28, my lord. Yes.
23.
But, my lord, I must tell your lordships, this is not under challenge now. But this was, I'm just saying, this was to bring it in conformity with the Constitution.
Just let's have a look at 28.
28, my lord. No religious instruction shall be provided no religious instruction shall be provided in any educational institution wholly maintained out of the state funds.
Now, in 1951, this was a religious, this institution was maintained by, wholly by state funds?
May not be done, may not be wholly.
No, wholly we'll have to exclude small little fees, etc. But it was,
Otherwise, yes.
it was wholly.
Yes.
Yes, in fact, it is your argument that
Yes,
it was
yes.
wholly.
They were having some minor.
So there is a bar on providing religious instructions in institutions wholly maintained by state fund. Now,
Correct.
2.
Nothing in clause 1 shall apply to an educational institution which is administered by the state but has been established under any endowment or trust which requires that religious instruction shall be imparted in such institution.
So the exception carved out here,
Yes, this
where
is,
it is administered by the state, but the establishment is by the religious institute. It's a trust or endowment which is established there. The religious instruction can be given.
Yes.
Now read 3.
no person attending any educational institution recognized by the state or receiving aid out of the state funds shall be required to take part in any religious instruction that may be imparted in such institution or to attend any religious worship that may be conducted in such institution or in any premises attached thereto, unless such person, or if such person is a minor, his guardian has given his consent thereto.
Okay. According to you, as on the date when Constitution was enforced, which part of Article 28 will apply? Which clause of Article 28 will apply?
No, 3.
Not 1 and 2?
1 and 3. 2 may not apply, 1 and 3.
1 applies, then is it possible for that institution to grant or permit religious instructions?
One is absolute, my lord, that's what your lordship said. It may not be permissible, my lord. As the Constitution reads, my lord, it may not be permissible. But, my lord, possibly it.
Then when we, the the 1951 amendment, which is is in terms of three. To give an option, when you say three applies, indirectly you are accepting it as a minority institution, because three only applies to minority institutions.
No, my lords.
Yes. No, not, sorry. It applies to non-state funded institutions, only non-state funded institutions.
Yeah.
You're right to that.
Yes, yes. So, my lord, but in any case, this is not.
Or in case of state funded institutions, which are minority institutions, three obviously will apply.
Now, my lord, section 9 was deleted, my lord, if your lordship sees, my lord. Section 9, my lord, which required, please see, my lord, 9, original act. The court shall have power to make statutes providing.
Let's go back to Article 28 and the proviso to section 8.
I'm sorry, my lord, I was little taken.
We'll just go back to the proviso.
No, I was on the last point, my lord. My apologies, my lord. But I genuinely feel I can and I will.
Sorry?
81. The 81 amendment, my lord. My apologies for that.
No, the 81 amendment, let's see section 8 for a moment. We were looking at section 8 at your on
yes.
that page.
As it stood, my lord?
No, after the 81 amendment, because the 81 amendment is in red.
You know, 51 is in there.
Sorry, I'm sorry. I'm sorry. I meant the 51 amendment. The 51 amendment is in red.
Correct.
Now, what the 51 amendment does is introduces the proviso, provided that nothing in this section shall be deemed to prevent religious instruction being given in the manner prescribed by the ordinances to those who have consented to receive it.
Correct.
It expressly allows for religious instruction in AMU, subject to the consent of those who are receiving religious instruction. Now, under what provision of Article 28 does this proviso to Section 8 fall? If you look at the first clause of Article 28, the first clause of Article 28 interposes a complete bar, right? See Article 28(1).
No religious instruction shall be provided in any educational institution wholly maintained out of the state funds.
No, it is maintained out of state funds. For a moment, we'll take it on the basis that it is wholly maintained out of
Correct,
state funds. So, any form of religious instruction would ex facie be barred in AMU by virtue of the provisions of Article 28(1). Now, Article 28(2), Clause 2 lifts the bar to a certain extent.
Except
right?
For two exceptions.
Right.
Yes.
Now, where does it lift the bar? Let's read 28(2). Nothing in Clause 1 shall apply to
I'll read. Your lordship, shall apply to an educational institution which is administered by the state but has been established under any endowment or trust which requires that religious instruction shall be imparted in such institution.
And now what does 3 do? That no person who attends such an institution, a state-aided institution, will be compelled to undergo religious instruction unless the parent or guardian has consented. This puts the requirement of consent. So clause 2, then otherwise there would have been an absolute bar under clause 2, Article 28(1). What clause 2 of Article 28 does is to lift the bar. In the case of an institution which may be otherwise administered by the state, but which has been established under an endowment or trust which requires that religious instruction shall be imparted in such institution. So,
2 doesn't apply in fact.
Proviso, perhaps, the proviso to Section 8 is in recognition of, is an implementation of the provisions or is pursuant to the provisions of Clause 2 of Article 28. But for Clause 2 of Article 28, that proviso would have run afoul of Clause 1 of Article 28. So that proviso comes in as a result of Clause 2 of Article 28. Now, when it comes under Clause 2 of 28, it's in recognition of the fact that this is established by a trust or endowment, which requires that religious instruction has to be given or imparted in such institution.
So
that
the government
may be
is
the position.
Kind of bound by the covenants of that, my lord, trust or endowment.
Or trust.
Yes. Another thing, Two has no relevance. It's a different fact. Twenty-eight. Lord, one, Lord, my respectful submission is that even if there is some, Lord, some internal generation of money, possibly one may not apply, but that situation we are not facing. Here it would be three. That is why section 9 is deleted. Number one. Number two, 28 is
So
agnostic.
what it permits is, what the 51 amendment permits is, you can impart religious instructions in this institution.
Yes.
In
And,
this
my lord,
in
important.
education in this institution. So indirectly, they are saying that one will not apply. Now, one may not apply if the institution falls under Article 30.
No, not necessarily.
We'll have to harmoniously interpret Article 28 and Article 30.
May I, my lord, answer that question, my lord? Lord, may I give one more? Yes, sir. Hmm.
Yes. We will. We will.
lordships can, my lord, at this stage examine. 28 is an agnostic provision. It applies to minority as well as non-minorities.
Correct?
So even if it is a minority institution or non-minority institution, one says
It
if
enforces
it is
that-
wholly,
It introduces the character of secularism in education.
yes. And three kinds of a take a middle path that all right, if you wish to, you provide, but don't compel. And even in case of a minority, my lord, academically and constitutionally, it is possible that a minority institution, say Hindu, the Muslim minority institution, may say that we will provide religious education both in Hindu studies and Islamic studies. What they cannot do, they cannot compel the students. So it is, my lord, the
3 is a
TM
provision which is against compulsion. What 3 does is basically to create an option. That's why 9 came to be deleted, really speaking in that sense.
exactly, I am obliged.
9 was deleted. Because
Simultaneously.
9 provided for compulsory religious instruction to Muslim students.
Yes, therefore.
Now, after the deletion of 9, it's not that religious instruction is done away with, but all students, Muslim or otherwise, have now a choice.
He may be therefore an exception to both 1 and 2. Read it carefully.
Another very important aspect of 3 is 3 applies even if you are not wholly maintained out of state funds. Because 3 merely says receiving aid. Receiving aid may be 5%, 10%, whatever. Once you are receiving any aid, then 3 applies.
Or
1 applies, 1 is wholly out of state funds.
so, meaning thereby, if you have a madrasa or a gurukul, for both, my lord, I'm saying, without receiving any aid, you impart religious education, not a religious instruction, no difficulty. But the moment you start accepting something from the government, constitution steps in, and whether,
This will be important. Just read 3 once again.
yes, my lord, no person attending any educational institution recognized by the state
So one requirement is recognized by the
Recognized.
state. Number 2 is,
or receiving aid out of the state fund shall
now
be.
here it's, the words are not used wholly funded by the state.
Correct, my lord, yes.
Any aid received by the state.
Not
So
wholly.
If not wholly. So if we read it as an exception to 1, then it may be permissible even for wholly funded state institutions to impart religious education.
Not wholly.
You're not accepting that position. Your position is if it's wholly funded by the state, then number 1 apply, clause 1 will apply. Be careful what you're saying. It may have repercussions.
Actually, clause 1 imposes an absolute bar. Right?
Correct.
That if you are funded wholly out of state funds, you cannot have a religious instruction at all. That's clause 1. Clause 2 lifts the bar, which is evident from the use of the words nothing in clause 1.
One, it's an exception to one.
It's an exception to 1. Now, what 3 does is 3 imposes a requirement when you are receiving any aid, or of course recognition. You're not in the recognition aspect right now. So 3 is conditioned if you are receiving any aid, even if you are receiving 5% aid or 1% aid from the state, 3 applies. And what does 3 say? 3 says is that you can have religious instruction, but you can't make it compulsory, unless in the case of a minor, the parents or the guardian consent. Therefore, 3 in that sense, 1 applies only where you are wholly funded by the state. Even if you are not wholly funded by the state, you cannot compulsorily have religious instruction, which therefore means that if you are not funded by the state, you can make religious instruction compulsory. There's no difficulty. If you are funded by the state, whether wholly or in part, at the least, if you are funded in part, you are receiving any aid, because it says receiving aid. If you are receiving aid, you cannot have compulsory religious instruction. That's the purport of.
That's the middle of the way. Then if somebody wants,
But if you're wholly funded by the state, you cannot have any religious instruction at all. That's
even with
one.
consent. Even with consent.
Even with consent.
Is that the stand?
Even if you are not receiving
Pardon?
aid, but if you are a recognized institution,
Yeah,
then
and
you cannot come.
And recognized. So if it's either way, if you are recognized, but you're not receiving aid from the state, you cannot have compulsory religious
No,
instruction.
but therefore, if we accept your position, if it's a non-minority institution, can they impart religious education?
So, yes, subject to 28(3).
But then 28(3), as per the stand taken by you, will only apply to non-fully funded institutions.
So a non-minority institution which does not receive any aid, you can have compulsory religious instruction.
Yes, no, like you.
But even if you're a non-minority institution and you're receiving any aid from the state, you can't have compulsory religious instruction.
Correct. And
So
therefore, 9 is
28(3)
deleted.
applies. 28 is agnostic to whether you belong to the minority or otherwise.
Correct.
28 applies
No,
across.
that's not TMFI also recognized.
Minority or non-minority.
As Brother Suryakant says, 28 draws no distinction between whether you are a minority or non-minority.
No, that's what I say. 28 is agnostic provision, whether you are minority or non-minority. It is
Also because 28 occurs in a subtitle or subpart
Exactly,
called
Manoj.
Right to Freedom of Religion.
Yes,
that
Manoj.
applies to everybody.
29 and 30 only talks of
Cultural
minority.
Cultural and educational rights.
Yes. And 29 and 30 only uses the word minorities.
Institution.
I can always support.
Other people.
Necessary for the reason that 51 amendment is not under challenge.
No, we are interpreting.
Yes.
We are just interpreting. We are not going into the merits or demerits of 51
Yes.
amendment, but the impact thereof. You see, if we accept this argument,
Well,
then it
therefore,
will be a minority institution which is fully funded by the state cannot impart religious education.
correct. And
And in spite
once,
of Article 30, Clause 1.
my lord, once section 9 is deleted, compulsory education in Muslim students, look, whatever limited minority status was there, that also went in 51. Compulsory education,
On Article Clause 1 and 3 of Article 30, 28.
TMA 5, my lord, I'll just read.
Does it deal with that issue? Question.
Yes, my lord, kindly see, my lord, page. This is 5A, para 144, page 651, my lord. 651.
Not there in this document.
So there, the context was little different, but 28 is discussed. But my respectful submission would be in facts of this case,
Has this legal position been interpreted? The Article 28 been interpreted?
yes. Yes. Lord, please see page 140, para 144, my lords. Lord, page, volume 5A, page 651. The discussion in 11 judge bench judgment of TMFI about 28. My Lord Justice Mishra and Justice Padiwala. May I read, my Lord, para 144. It cannot be argued that no conditions can be imposed while giving aid to a minority institution, whether it is an institution run, this is post-constitution,
What page number?
651. Please kindly bear in mind, this is post-constitutional scenario.
Yeah.
The earlier conditions can be imposed. The Britishers were not bound by 30 or any other fundamental thing. It cannot be argued that no conditions can be imposed while giving aid to a minority institution, whether it is an institution run by the majority or the minority. All conditions that have relevance to the proper utilization of the grant in aid by an educational institution can be imposed. All that Article 30, Sub-Article 2 states is that on the ground that an institution is under the management of a minority, whether based on religion or language, grant of aid to that educational institution cannot be discriminated against if other educational institutions are entitled to receive the aid. That's Article 14, my Lord. The condition for grant or non-grant of aid to educational institutions have to be uniformly applied, whether it is a majority-run institution or a minority-run institution. As in case of a majority-run institution, the moment a minority institution obtains a grant of aid, Article 28 of the Constitution comes into play. When an educational institution is maintained out of state funds, no religious instruction can be provided therein. Article 28(1) does not state that it applies only to educational institutions that are not established or maintained by religious or linguistic minorities. Furthermore, upon the receipt of aid, the provisions of Article 28(3) would apply to all educational institutions, whether run by minorities or non-minorities.
So really speaking, right, and therefore the court says that 28 applies both to minority and non-minority institutions. 28 applies to both.
Provision, because right now we are in the mental framework of religious
28,
minority.
once you receive aid or you are recognized within the meaning of 28(3), then the provisions, 28(1) applies once you are wholly funded by the state. And 28(3) applies whether you are receiving part aid or full aid, or whether you are recognized. Then 28(3) the bar comes in, that you cannot compel religious instruction. That's the... And it is not as if 30 overrides 28. The prescription in 28 applies to a minority institution as well.
As well. Lord, kindly.
That's the same.
Yes.
58.
Page number?
Page number 5.
TMA 5.
Which page number?
This page is.
What is the page number?
550.
This is 626.
626.
626.
626. And that would while Article 28(1) and 28(2) relate to your Lordship's got that. While Article 28(1) and Article 28(2) relate to institutions that are wholly maintained out of the state funds, Article 28(3) deals with an educational institution that is recognized by the state or receives aid out of the state funds. Article 28(3) gives the person attending any educational institution the right not to take part in any religious instruction, which may be imparted by an institution recognized by the state or receiving aid from the state. Such a person also has the right not to attend any religious worship that may be conducted in such institution or in any premises attached thereto, unless such a person is, or if he or she is a minor, his or her guardian has given his or her consent. The reading of Article 28(3) clearly shows that no person attending an educational institution can be required to take part in any religious instruction or any religious worship unless the person or his or her guardian has given his or her consent thereto. In a case where the educational institution has been recognized by the state or receives the aid out of the state funds. We have seen that Article 26A gives the religious denomination right to establish an educational institution, the religious denomination being either of the majority community or minority community. In any institution, whether established by the majority or a minority religion, if religious instruction is imparted, no student can be compelled to take part in the said religious instruction or in any religious worship. An individual has the absolute right not to be compelled to take part in any religious instruction or worship. Article 28(3) thereby recognizes the right of an individual to practice or profess his own religion. In other words, in matters relating to religious instruction or worship, there can be no compulsion where the educational institution is either recognized by the state or receives aid from it. Article 29 and 30 are a group of articles relating to cultural and educational rights. Article 29(1) gives the right to any citizen of a section of citizens residing in India or any part thereof and having distinct language, script, or culture of its own to conserve the same. Article 29(1) does not refer to any religion, even though the marginal note of the article mentions the interest of minorities. Article 29(1), it can be linguistic. 29(1) essentially refers to sections of citizens who have a distinct language, script, or culture, even though their religion may not be the same. The common thread that runs through Article 29(1) is language, script, or culture and not religion. For example, if any part of the country there is a section of the society that has a distinct language, they are entitled to conserve the same, even though the persons having that language may profess different religions. Article 29(1) gives the right to all sections of citizens, whether they are in minority or majority religion, to conserve their language, script, or culture, etc. But I may read further. But for example, Gujarati being a linguistic minority in say Delhi, may provide for an institution, and it may have people from Muslim community, Hindu community, Parsi community, all speaking Gujarati language. So what is binding is the linguistic minority character or some kind of a culture. That's what 29 provides.
But Parsi Gujarati is very different from Gujarati Gujarati.
That is true. That is true.
A little more colorful also.
Sometimes extra colorful. So, the Parsi abuse doesn't feel like an abuse. They abuse it in such a way, that lovingly. Your Lordship knows, my Lords have the experience.
Abuse lovingly.
What?
I said Gujarati knows.
I don't bring,
No, but,
I am not a man in, anyway, I am just.
Time two may also be read, it's important.
29(2).
No citizen shall be denied admission into any educational institution maintained by the state or receiving aid out of the state funds on grounds only of religion, race, caste, language, or any of.
So we have now examined that, we have examined the 65 amendment, 51 amendment. Now we go to the 65 amendment.
Yes.
That is the orange amendment, right?
Yes.
Orange is basically in section 23, the 65 amendment.
Yes. There is no other change, my lord.
Only
There are some
23.
changes, my lord, in, no, there is none.
I think,
There-
23, just let's see what happened in,
23, my lord, the court. The court shall consist of the chancellor, the pro-chancellor, and the vice-chancellor for the time being, and such other persons as may be specified in the statute.
then subsection 2 is deleted.
Is deleted. The court shall be supreme authority, etc., etc. Please turn the page, my lord, over. And it is given, my lord, advisory function. In accordance with, I'm sorry, ma'am. Statutes. My lord, the functions of the court shall be to advise the visitor in respect of any matter which may be referred to the court for advice, to advise any other authority of the university in respect of any matter which may be referred to the court for advice, and to perform such other duties and exercise such other powers as may be assigned to it by the visitor or under this act. Lord, this
This was 65 amendment.
was 65.
What happened in 72? Anything substantive in
Ye-
72
ye-
or?
yes, my lord. Lord, please come to, my lord, section 23 only. Lord, there is no major change, my lord, in other aspects, except, my lord, some powers of the vice chancellor are improved. But 23 in 72 Act, the constitution of the court and the term of office of its members shall be such as may be prescribed by the statute. Subject to the provisions of this act, the court shall have the following powers and functions: to review from time to time the broad policies and programs of the university, and to suggest measures for the improvement and development of the university, to consider and pass resolutions on the annual report, annual accounts of the university, and audit report thereon, to advise the visitor in respect of any matter which may be referred to it for the advice, and to perform such other functions as may be prescribed in the act.
Sorry,
Wait, wait.
look at the original act 17 and 18 also,
17.
17 and 19.
Yes, ma'am. Lord, please come to 17.
There's some provision in 19.
Chancellors shall be elected by the court.
Yes, ma'am. No change in 51 and 65.
Now,
72, they made that change in
Yes,
bold.
Lord, the chancellor shall be appointed by the visitor in such manner as may be prescribed by the statutes. The chancellor shall, by virtue of his office, be the head of the university. The chancellor shall, if present, preside at convocations of the university
that's
held.
not relevant, that's not right. But what is relevant perhaps is that prior to in the original enactment, the successors to the chancellor shall be elected by the court.
Court. Now,
And number two, vice chancellor also, the successors to the first vice chancellor shall be elected by the court amongst its members.
yes, ma'am.
After the amendment, they will be appointed by the visitor.
By the visit.
But such
One-
appointment shall be subject to the approval of Governor General and Council. Vice Chancellor is concerned.
One very interesting amendment which was made in 1972, come back to section 5.
Yes,
See 5(2).
yes.
University shall have the following power. 5(2) was to promote Oriental and Islamic studies and give instruction in Muslim theology and religion, and to impart moral and physical training.
This was original.
B now comes in.
Yes.
It
To-
says
to
to promote the study of religion, civilization, and culture of India.
Of India, not one religion.
Becomes more secular in its
More
form.
secular.
And then
And
comes
thereafter-
81. And then comes 81.
Yes, my lord, please
81
come to
is green,
81. my
right?
lord.
Green is 81.
Lord, definition clause. Please come to the definition clause. This does not stand as of now, my lord. It's set aside. L, my lord, 2L.
University.
Yes, university means
Just
Aligarh.
Just one.
The Lordships have 2L, my lord. Lordship C. L.
Yeah.
University means, Lord, originally it was Aligarh Muslim University, the educational institution of their choice, established by the Muslims of India, which originated as the Mohammedan Anglo-Oriental College, Aligarh, and which was subsequently incorporated as the Aligarh Muslim University.
In what the amendment of 1981 did was to squarely sort of give it a minority status. That was the object. Because two things they did. They deleted the word established from the preamble, and in the definition of university, they now take it, it's a recognition that, well, this was established by the Muslims of
Whether
India.
that can be done or cannot be done is a subject.
No, that's a separate issue.
That's a separate issue. That's
But
what they did.
What
Yes.
was the purport of the amendment?
Yes, bro. That's what they did. Parliament did not.
Freedom fee. So, start.
Solicitor, it's well settled that the legislature, whether it's a state legislature or parliament, can take away the basis of an act of the basis of a judgment. So, for instance, if a judgment holds a statutory provision to be violative of Article 14 on the ground that it does not comport with natural justice, the legislature can introduce a provision for natural justice so as to make it in conformity with the law by supplanting the deficiency which was noticed by the judgment. So what you can't do is to directly override a judgment, right? So, for instance, the classical case was Madan Mohan Pathak, where there was a binding settlement, an industrial settlement, on which a mandamus was issued by the Supreme Court. That settlement was sought to be overridden by an amending provision, which the court held this you can't do because it has attained finality. Now, what does 2L do? 2L, or before we go to 2L, what did Basha do? Basha said that AMU was not established by a Muslim minority, but was established under an act of the imperial legislature, right? And it is administered by the minority, but is administered by this institution, by the act. can by merely an amendment to the definition, can you take away the basis of Bhasha? Because
Lord, my
what
legal
2L does, possibly what the argument, and this we may have to hear the other side in response because this was not argued in the opening, that 2L merely alters the definition of the expression university. But does the alteration of the definition of the expression university take away the basis of Bhasha? That the very establishment, now what the 81 amendment does is, it doesn't purport to establish the university at all. Now, it says that the word establish is taken away from the preamble.
but incorporated remains.
Incorporated remain. Then 2L says that it was established by the by the Indian Muslims of India, originating as the MAO College Aligarh,
Correct.
and which was subsequently incorporated.
The argument rejected is in Bhasha is incorporated by way of a definition.
Now, is this amendment, by the way, in 81, is it retrospective or is it prospective?
Lord,
Lord, our argument before the Allahabad High Court is it's declaratory in nature and therefore retrospective.
Necessarily retrospective.
That was the argument.
Lord, I don't wish to give examples, but if you can change history by changing definition in a statute, your lordships can, with your lordships' wide experience and wisdom, visualize, Lord, what can be done. There are several historical facts, my lord.
No, Parliament
which
can do it.
May, my lord,
But
Parliament
no,
think of
Parliament
change.
has the power to do it. Parliament has the power to do it. Because Parliament can, while implementing a statute, subject to a challenge under Article 14, Parliament can. say that the
Competence,
court-
yes.
It has the competence to say this
But
is our
whether
view
it
when we enact
amounts
the law.
to effacing
certainly
Bhasha or not, that's a question.
That the more important substantive point is this really declaratory as they are arguing? Or are you merely amending the definition without taking away the basis of Bhasha? The latter you cannot do. The former you can do.
You can't sit in appeal. The Parliament cannot sit in appeal and set aside the judgment. It can, if there is some lacuna found by the court, that lacuna can be filled up. But, Lord, it is my submission, and
So Bhasha said that AMU was not established. Says AMU was not established by the Muslim minority,
intra-party dispute
but
is
it was
decided.
established under an act of the imperial legislature. Can merely an amendment to the definition of the expression university take away that basis of Bhasha?
And, my lord, their argument that it was established by the educational institution of their, by Muslims of India, which originated
Because
at
to
so
take away the basis of Bhasha, you have to take away the underlying facts on the basis of which Bhasha has been decided. Have they really altered those underlying facts by this amendment?
I requested your lordships that I would like to read Bhasha the way I request your lordships to read. Bhasha doesn't say what they are apprehending. Bhasha is a sui generis Allahabad, Aligarh University case. And it defines and records certain factual findings also, which, my lord, this amendment of the Parliament seeks to do away with.
Is there an alternate reading not possible? I mean, we are discussing various options. I mean, we just because the idea, it's not an easy, it's a thorny issue. The original act said the university is established and incorporated under this act. The preamble says established and incorporated. Right? Suppose established was not there and it had merely used the word and incorporated under this act.
Only incorporated.
In which case, it would have been established by whoever it had been established by, but it was given a statutory form of a juristic personality by the original act of 1920. Now, Bhasha relied heavily on the preambulary provision, which says established and incorporated. That means you are setting it up for the first time by the Act of Parliament.
Even incorporation would
Is
be
it not
setting
open-
it up for the
right.
first time.
No, that may be a little different because incorporation is giving it a juristic form. Establishment is an establishment in fact. But is it open to Parliament? Is it, or put it the other way, is it not open to Parliament to say that, well, Bhasha relied on a statutory provision, namely the word established, to hold that it was established under an act and not by somebody divorced the statute. We will amend the statute to take away the word establish, so as to make it clear that our intent is that this was only given a juristic form by the Act of Parliament.
Can the
Can Parliament
intention
not do
of,
that? Can Parliament not do that?
Lord, can the intention of the Parliament as it existed in 20 be supplemented or amended, that this was the intention
That you can
after?
always do. That they can, there's no, Parliament's power is untrammeled.
Let that be argued. Lord, they were not comfortable in arguing this point.
uh,
They said, let it go to the regular bench. I am ready to argue. This is set aside by the division bench of a High Court by a
Parliament does
reason
that
order.
all-
I am ready to
Parliament
support.
does that all the time in the case of fiscal enactments. You'll have amendments by the galore in the Income Tax Act. The moment a judgment comes, they will amend it with retrospective effect.
My lord, this, my lord, there are, we have, my lord, judgments on.
These are what we call a validating statute or,
My lord, we have judgments, my lord, whether this can be done or cannot be done, and to support the judgment of the division bench of the High Court, and we have filed an
but
affidavit.
then one thing, let's have conceptual clarity on what we are going to write on. I mean, what is the canvas on which we are going to write? If they are not arguing on the.
They are not
validity-
ready to argue.
No,
We
ready to
want
argue.
them to argue.
They are not arguing. That's their choice. One second.
We shouldn't argue the 81 Act.
No, they said that let it go to the regular bench.
Just one
They
second.
say.
One second. We've got our notes. In the opening, they have said that they are not arguing on the validity of the 81 amendment, which forms the subject matter of the Allahabad judgment. So, for the purpose of this reference, then, do we proceed on the basis that the 81 amendment is a valid amendment?
It cannot be.
Oh, sorry,
This-
the 81, the other way around. Amendment is now effaced from the statute.
Yes, my lord, it's not, it does not exist on
By
the,
this court.
Ah.
Mullahs,
it's not stayed, it's not stayed. The court said status quo because
No.
they have granted reservation.
One second.
That was the state, therefore say that the
Where
status quo.
reservation, it is not state, otherwise it's status quo ante.
No, I'll show the
The
order.
order of the court. It's there. It is status quo ante.
No, you have-
Other than the
You
issue.
can't have it both.
If- if-
Let us be very clear.
If I remember correctly, what had transpired was, we were, that in case it's a minority institution, then the corrective will be in terms of the constitution and the right protected under Article 30. So we're going on that basis.
All,
But to be fair to the solicitor, the argument of which has been raised is that in Badshah, the court found three things. One, it was legally established. Two, in fact, de facto also, it was established not by the state. It was established by the state and not by the minority institution. And third, it is not administered by the minority. These are
And
three.
four, you have, whatever rights you had, you have surrendered those rights.
So that is
That's a
part,
factual finding.
that's part of the second, that it was not established and administered. It's a part of second and third itself because you surrendered.
So
those.
that factual
So-
finding that you have surrendered,
So your argument is even by adding even by deleting the word established from the statutory enactment, it will not unwind or rewrite the judgment of the
Aziz Basha.
Badshah's case, that it was de facto established by the state.
Mr. One more thing, Mr. Solicitor, I'll have a word with my learned colleagues over the lunch break. I'm just throwing this as an idea. It's not even my confirmed opinion. So it's just for the sake of a debate or dialogue in the court. You will also concede, and the other side will also concede, that the 81 amendment does have some bearing on the minority character of AMU. What bearing it has, it is for your argument, their argument, and we'll decide it. If we accept that the 81 amendment does have some bearing on the minority character of AMU, because let's face it, the object of the 81 amendment was to reaffirm the minority character. That's the whole purpose of 2L and that preambulary chain. Now, if the 81 amendment has some bearing on the status of AMU as a minority or otherwise, then can we really decide this without going into the validity of the 81 amendment? Otherwise,
that's precisely we requested.
because otherwise we'll be making.
No, that's precisely we
Because
requested.
our-
They were not comfortable.
because,
They said,
Mr.
go to the regular
Solicitor,
bench.
because look at it this way, Mr. Sibal, please look at it this way. We are a bench of 7. can our judgment be made contingent on what a bench of a lesser constitution will decide on the validity of this amendment? If this, take it against you for a moment, just for the sake of argument. Suppose we reverse the judgment of the Allahabad High Court. And this is only for the purpose of testing the hypothesis.
Yes,
Not at all. Our mind is completely open on the 81. But I'm just putting it against you because suppose we reverse the Allahabad High Court and affirm the validity of the 81 amendment, right? In which case, the consequence of the amendment of 81 is to clearly confer it or recognize it, as they say, the minority status, whether it is declaratory or confirmatory.
Maybe subject to certain arguments.
Yes,
which we may
that
make.
arguments are on both sides are open. In which case, how can we say that, well, we will decide this minority status of AMU dehosts the 81 amendment? And the moment you look at the 81 amendment, we have to necessarily look at the Allahabad judgment. So perhaps, I mean, we will all sit down at lunch.
But we have been
5 minutes.
saying that right through.
At lunch, we will all have a confabulation between us because I have not had the benefit of my
Kindly
learning.
not recall,
My
Lord,
colleagues
it was
views.
our case that your lordship will have to go into the merits. They said, no, this question may be decided by regular.
Mr. Solicitor, you can continue with the rest of your arguments. But if we come to the conclusion that we will have to decide the validity of the Allahabad judgment here, then you can deal with the validity of that judgment in your
No, but
argument.
first let them argue. Lord, at that stage, Mr. Dhawan got up and said that I'll take 2 days.
You can support the judgment and we will hear them in response. That will be much faster. Otherwise, then we'll have to again go back. to Mr. Solicitor to argue.
Let them have, my Lord, the.
My specific submission in the written submissions is that the 81 amendment is valid. Specifically there.
Obviously,
But
that's
once
the
the
case.
lordship said, let it be decided by the other bench, then I didn't complete the argument.
No, my
No, I
Lord.
thought.
Getting away from it.
No, he
Doctor,
said that. it-
my recollection is that you said, I am not going into that, let it go into the.
Yes, and let it be done by the regular bench. That was Mr. Dhawan's submission.
If I remember correctly.
On our side, we were saying that you will have to decide it.
We are not hesitant.
All of us
to-
from this
we are
side.
not hesitant, but if I remember correctly, I had said, if you,
In
Maharaj,
on something.
हमारी सबमिशन कहाँ?
The consequence of the interim order is that AMU said we will not implement the 50% reservation. But the status quo, as on the date of the filing of the writ petition, was to be maintained. That is to say, when the petition was filed, Brother Dipankar Datta says 2004, the 81 amendment had already been brought into force. Therefore, the 81 amendment today, as a result of the interim order of our court, is operative.
that's right.
But the question is, my Lord, without going into the validity of that judgment,
Uh-huh.
it would not be possible for your lordships, my Lord, in this.
Prima facie, you may be right on that. Mr. Sibal, just reflect on it at
No, we'll
last.
reflect, but what I said,
Stay of judgment.
1 second.
That's not stay of judgment.
Judgment, my
No,
Lord.
Neeraj, look at the other, the latter part.
That's
The
quite-
latter part, that the status quo will be maintained as on the date of the filing of the writ petition.
That is
And
for
if you-
reservation.
That's for reservation, and also, my lords, the next line, since your lordship said, should we consider the 81 issue? The next line says it's desirable,
After the
and the larger bench
Then
considers
stay
the
of the
judgment
judgment.
also. Because your lordship
May- may-
There
question,
is no stay of the Allahabad judgment.
operation
per
of the
se.
judgment has not
There
been.
is none. There
there's
is
no
no.
stay of the Allahabad judgment.
May I say something, bro? May I say? No, may I give a little background?
Yes, it's status quo, Maharaj, for all other matters.
That is only reservation.
Put the question that should your lordship
Maharaj,
get into the 81 issue,
If your lordship,
81 amendment, the same order says that it is desirable
that this matter should be considered by a larger bench, and your lordship that today seized of the matter. The same order in the next
What
case
has
happened, is desirable.
What has happened, and I'm going to make this sufficient good. It is there, that matter be.
That's,
The matter is referred, not the question. That's the,
I
that was
remember.
our case.
If I remember correctly, Malaj, I had argued,
Don't argue and then.
if
now-
you set aside Basha. then
No, there is no setting aside. This is not an
If
appeal.
you do not agree with Basha, then 81 amendment doesn't arise. That's what I had said. If you do not agree with Basha, then the 81 amendment need not be gone into.
that's-
It's so, if, what my Lord the Chief Justice said is right. If you say that Basha was right, Malaj, then the question of 81 amendment comes in. But if Basha was wrong, 81 amendment need not be discussed.
Vice versa.
For
what I-
deciding whether it is right or wrong,
Allow me, sir, to conclude.
81 will have to be examined.
I am not saying no, I'm just, please allow me. So if your lordships, Malaj, on our argument says that Basha is wrongly decided, you don't have to go to the 81 amendment. So decide that question, Malaj. What's the problem with that?
Point, Mr. What you are saying, look, Parliament amended the Act in 1981 to really, should we say in a colloquial sense, to override Basha,
That's right.
right? Now, what you are arguing is that if you come to the conclusion that Basha was wrong,
Yes.
then there was no question.
Yes.
But even so, if we come to the conclusion that that Basha was wrong, we'll have to still, we'll have to still deal with the validity of the 81 Act.
No, but then, Malaj, it goes without saying whether it is trying to override the judgment or not. It is established by the minority, recognized under.
But suppose the lordship decides that Basha is right, then what?
No, don't allow. That question will not arise.
What happens then if we decide that Basha is right?
If the Basha is right, Malaj, then the 81 issue will have to be gone into.
Only then.
Then by
only-
the regular bench, that's their,
Then only. to
That is,
Problem is
that's
just
the only issue that is referred to your lordships, Malaj.
Just now you
Whether
said
Basha
that
is right or
1981 amendment survived.
Yes.
Problem is that just now you were saying that 1981 amendment is still operative.
If
Now,
if your lordship
your
agree
argument
with
is that
Basha,
it is still operative, then we have to go into
your
the
lordship
validity of
agrees
that.
with Basha, Malaj. If your lordship agrees with Basha, then of course the 81 amendment is there. If you disagree, yeah. No, don't look at it. Don't look at it today, Malaj. Just look at Basha. Is it right or wrong? And if your lordship says the Basha is wrong, 81 doesn't matter.
what if the court says Basha is
That
right?
becomes an academic issue. Why? Because it is established by the minority and under 31 Malaj is recognized.
If we say that Basha is wrong,
Yeah.
then according to you, then the amendment in that sense recognizes what we feel also is the correct position.
Then, Malaj,
So what if we come to the conclusion that Basha is right?
then you have to go into the 81 Malaj.
But then if we say that Basha is right, then who goes into the 81 amendment?
Malaj, that it is not referred to 7 judges. The 3 judges who would hear it will go into it.
That's the problem.
No, it's not a problem. That's the process.
That's not the.
That's the reference is only que Basha. The reference is not que the 81 amendment. I don't think that we should refer, that we should go into that.
Conveniently, keep having a bite again.
reflect on this at lunch. In deciding, your argument is that if you come to the conclusion that Basha is wrong, then the 81 amendment really becomes redundant. But just reflect on this. Can we decide on whether or not Basha is correct without looking at the statute as a composite whole, including the 81 amendment? Okay, technically today, true, as the solicitor said, 81 amendment is now not on the statute book because it has been set aside by the Allahabad High Court. But everything is live before our court. Now, may not be live before the 7 judges, but it's live before the Supreme Court. Therefore, in deciding whether Basha is right or wrong, Basha itself has interpreted the provisions of the statute while coming to a conclusion, right? It relies on all the provisions of the statute.
That's correct.
Now, can we, while deciding on the correctness of Basha, say that we will look at only some of the provisions of the statute, but we look at the statute minus the 81 amendment? That may be very artificial for us.
The Lordship, the problem. I tell you, Lordship, the
Just look
problem
at it
that will
that way.
arise. If I may, I'm sorry. Then your Lordship, just give me a few minutes, Malas. Either we look at Basha and on the basis of what happened in 1920. That is, look at Basha through the lens of 1920. Or we look at Basha in the context of Article 31 when it came into force in 1950 and what happened thereafter. His argument throughout has been, don't look at anything else, look at what happened in 1920. That's been his argument throughout. What? If you don't want to look at Basha in the context of 20, please then look at this in the context when the Constitution came into force. Then apply all the principles of constitutional law in Article 30 to look at Basha. Then you'll have to do that also. And then 1981. That's not an easy exercise.
Lord Basha also examines
Therefore,
51
that question
and
will arise.
65th amendment.
Therefore, you'll have to look at Article 30, sub-Article 1.
And
You don't look at Basha
amendments.
on the lens of 1920 then. Then you'll have to do into all that. And my respectful submission is, Malas, that exercise need not be done. We are ready to, Malas, to argue Basha in 1920. Because that's how it happened. And that's throughout what has been said. Look at the Constitution, look at the regulations, look at what Basha says, look at what the rector said, look at what the chancellors have appointed. This is all Basha 1920. We'll answer that.
Basha, on the basis of the position as it stood in 1968.
Yes. Look at it and see whether it's it was established by a minority or not. It's all you have to look at.
There is one more aspect, my lord.
Let me just finish.
Supposing, my lord, your lordship considers 1981 Act also, and your lordship holds that that act is valid, it's unnecessary to examine Basha.
You are right, Mr. Deveri, but it's equally valid in case we hold that
I'm
Basha
just
is.
saying consider together, not
So,
fight.
so the 81 Act, if it is valid, then Basha in any case is overridden then according to us, because, I mean, that's the argument on.
Even if Basha remains valid, the new act has come which is valid and therefore.
What they want to do, let me put it in
Basha
order,
relies
this is
upon-
blunt,
there's
what
only
they
one-
want to do.
Basha relies upon 1951 and 1965
Amendment
amendment.
also, yes.
If part of the 1965 amendment has been done away with the 1981 amendment.
1981.
Yes, you go into that whether it was done validly or not.
Impossible to separate this.
Not looking at Basha in the context
That's
of
what we were saying
51
from
or
the beginning.
65.
Truncating.
You're not looking at Basha in the context of 51 or 65.
On one basis. This issue had come up earlier and we discussed and thereafter we proceeded on this basis. We are examining the validity of the ratio in Basha.
That's all.
What, number one. Number two, the reason was, why we said so was, we have to see the status of AMU as on the date when Constitution was enforced. In case we come to the conclusion, just 1 minute, please. In ways and Badshah, when we read, we found there were 2 aspects dealt with specifically in Badshah, or rather 3 aspects which were specifically dealt with in Badshah. One is, what is the effect of statutory enactment of a university, of grading a university? Basha says this is the enactment which establishes the university. This is the only aspect dealt with in 1981 amendment. The second aspect dealt with in Basha. Now we can hold, this bench can hold, yes, the statute established the established the university and therefore AMU came into existence. In which case we uphold that, then 1981 amendment has to be examined. And that can be examined by a separate bench, because then the limited issue is what is the consequence of that amendment. Number one, there the argument which will arise is, could the legislature, by merely deleting the word establishment, override the judgment of this court? That will be the issue, which is a separate issue. We have not addressed, nobody has addressed us. We have already gone through by about 5 days or 4 days. Nobody's addressed us on this. The second aspect, the second aspect which is dealt with in Basha relates to administration. And it says it is not administered by the minority right from 1920 or as of in 1950. That's the most important legal issue, because both the sides concede that both the things have to be, in order to be a minority institution, it should be established as well as and administered. So that's the legal issue. The third point raised is, beholds the amendment made in 1981. The Basha holds it's not established, de facto established by the minority, and that issue is again before us. So really speaking, we need not go into 1981 amendment per se to decide whether Basha is rightly decided or wrongly decided.
So, Solicitor, what, Ms. Dwivedi, just 1 second. What we'll suggest is this. You are in the midst of your argument, replying to them on merits.
Yes.
You can conclude your argument. Anyway, even if we decide to go into the validity of the Allahabad judgment, you said they should open first. We understand why you're saying that, no difficulty. So on this aspect, you complete your submissions. When we read Basha with you, again, we will be able to then fine-tune our own understanding on whether that issue of the Allahabad judgment should or should not be decided together. We will read Basha with you. So when you are reading Basha with us, or for us, you can also focus on these issues which Mr. Dwivedi, Mr. Kaul and you are saying requires us to also decide the issue of Allahabad in this reference. So right now we can continue with your submission, because you're now on the almost at the latter fag end of your at the end of your submissions.
Certainly, that's not the.
So we'll conclude your submission.
Really this.
It's the appropriateness.
Yeah, appropriateness. We will hear you at the end once you have argued on Basha.
Only give me.
We will hear you for 5 minutes on that, and then we will hear the others anyway, because this has to be dealt with. The merits everybody will argue. Then on the appropriateness of considering the issue of Allahabad as well, we will hear each of you and then take a call.
I'll just add one thing. I'll just add one thing. I bow down.
That's fine.
Lord, what has happened is this.
As far as the 51 amendment is concerned, Basha says it was just in conformity with the Constitution. We have argued that the 65 amendment was an emergency amendment, but it was reversed in 81. To that extent, my lord, we can certainly go into it depending on what
It's not separable. On this argument, it's not separable.
Now you have shown us this. We have anything else that we need to see in the chart, so that then after lunch we can.
The chart, my lord, is.
Now,
but, my lord, what is happening?
What is the remaining part that now?
What is happening is this. And let me, my lord, be a little more clearer rather than being diplomatic. What they want is, they are taking a chance whether Basha is right or not. If your lordships are satisfied that Basha is right, they will have a second round to say that even if 7 judges said Basha is right, now have a second round that now the disease is taken away and refer this question.
No, if Basha is right, no.
But that may not happen. In case we uphold Basha or agree with the ratio in Basha on the second and third aspect, they may not have any say in it.
My lord,
On the second and third aspect, that is de facto, it was established by.
No, I think what perhaps Solicitor is arguing is that if we come to the conclusion that Basha is right, then the issue of the validity of the 81 amendment will be before a lesser bench, a lesser
yes,
constitution.
that's what we want, a second Around, my lord.
The argument there
And-
could be that, look, the basis of Basha is taken away by the
Therefore,
1981.
no need to go into this, that's all, Manoj. That's all that there will be.
That's exactly what is the problem.
But there would be
That
like-
exactly is.
There is no problem, you don't have to
You
go into
can't
it.
have, my lord, this kind of
When
second bite at the
seven
cherry.
judges say Basha is wrong, what else
We
is
can't
left in
deal
the
with
matter?
7-judge bench like this, my lord, that you decide what is comfortable to me and don't
I
decide
think you are
what.
more hurt about it than the 7 judges.
Both should be decided together. That's the appropriate.
Lord, you
Meaning,
the reference is the matters are referred.
On this, we'll just defer it a little bit. You conclude your arguments. We'll also read Basha with you. Once we reread Basha with you, you would have read Basha with two different
I
perspectives.
need to read, my lord, some debates in 65 and that, my lord, that would be very crucial.
All right, so now after this, you'll be referring to the debates
Yes,
and then directly take us to Basha, or what's the?
yes, that's the.
And then we'll conclude.
there is only one thing I must.
So I guess about 20 minutes for the debates
No,
and about half
I'll
an hour
I'll
for.
take, my lord, 7 sessions. I'll not repeat anything,
No
not
difficulty.
repeat anything.
So, but now what remains from your argument is the debates and then followed by Basha.
Basha and, my lord, few other points.
But there is only one thing I must point out, the legal obstacle for them is the court suggested by them. If Lord Basha is to be considered independent, not in the right of 81. Virtually these proceedings will be sitting Lord like an appellate proceeding.
That is going to be my submission.
One principle, Lord, larger bench can go into the ratio, not the decision in that case. That's what you.
Not the factual findings, my lord, that is going to be my submission.
To convert the reference Lord into an appeal.
This is not an appeal from 5-judge bench to 7-judge bench, intra-court appeal. The argument was, look at this, what he says, look at this, what he says.
That's going to
Presently, look, we'll presently be open unless,
There are
until
some
we read
judgments also I'll
Basha.
be citing.
No, until we read Basha with the Solicitor General, let's, because, ultimately a judgment also depends on how it's, how it is interpreted by both the sides. So let's read Basha with you and then we'll take a final call.
And, my lord, there
One
are
more
some
anomaly, my
judgments,
lords,
my lord, on
reflect on that, my lord. Just one more anomaly. Assume, my lords, my lords decide that Basha is rightly decided. By relegating the 81 question to a smaller bench, they will get the opportunity to argue that notwithstanding Basha, 81 amendment is declaratory and curative, therefore Basha will not apply. Please see the anomaly then. 7 judges will have held Basha and thereafter
and have choice of two litigations, my lord, in a matter which are inseparable.
And again, anomalously, my lord, they'll argue what is something contrary to what is decided.
We'll not conclude an opinion at this stage. Let's, because solicitor is on his legs now. And we have almost substantially completed the arguments. One more session is what he requires. So today we'll finish anyway, even by his own